Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. Woo! Little distracted. My apologies. Not really. Like I am distracted, but not really that sorry about it. Oh, guys, life is a never-ending strain of curveballs that you have to deal with. I think that's the best way to describe it. Oh my gosh, especially these sideburns, need to get those cleaned up. Anyway, it's you know, as you get older, everything else is like just gets gayer. I don't know how else to say it. Like the stuff you have to deal with, you're like, why is this a thing? Because like you're like, oh, okay, you got this thing figured out and you're just going with it, and then you're like, what? Someone else comes along, they're like, oh, hey, nice life you're having right there. Let me just go ahead and stab it like a fucking hog. Anyway, that's just how it goes. But that being said, welcome to the show. Welcome to the show. Love you all for being here. Thank you. We have some stuff to cover tonight, like always. Always stuff to cover, I guess. This stuff is kind of interesting. So, you guys have been maybe noticed that I had Joe on last week, Tuesday, and he talked about a trial he's been watching, which is Trump's trial in Colorado. Not really Trump, but it's some people suing the Colorado Secretary of State to keep Trump off of the ballot there, saying he's disqualified under the 14th Amendment. And while Colorado were mere peons addressing this issue at the trial court level, Minnesota was addressing the same issue at the Supreme Court level, because if there's communist cuckery that can occur, it is occurring twice as hard in Minnesota. But Trump got some good news today. The Minnesota Supreme Court determined that he does get to stay on the primary ballot, which sounds like a great win. But the wording of the ruling leads us, I guess, to the conclusion that it's not much of a win at all, and that the issue is merely postponed until after the primary, assuming Trump wins it, which seems like a pretty safe assumption, and that then the issue can be fully looked at and explored. So we're going to talk about that. The opinion's pretty short. It's 4 pages, but it does get to some interesting questions about the procedure going on and what it says, while avoiding the most important and critical issues around whether or not Trump can be included on a general election ballot in a state, or if he, more appropriately, if he can be excluded from a ballot of a general election in a state based on his quote unquote incitement and participation in an insurrection against these United States, disqualifying him under Article 3 of the 14th Amendment, which is, by any reasonable read of the statute, completely fucking ludicrous. But hey, we're going to talk about it because, it's something to talk about. It's going on, and these challenges are going to continue as primaries progress and as Trump becomes the nominee, outside of something rather unpredictable happening, which would be Trump not becoming the Republican nominee. A lot would have to change before that occurs. But that being said, that's not the only thing. We are going to eventually get back to the Second Amendment case that we were reading yesterday. Now, I know it's thick law, but we had just gotten to the application of their, what I would consider, faulty Second Amendment analysis to the actual statutes at issue and the cases that they're brought under, or that they're challenged under in this suit. And I wasn't sure if I was going to read this, but I started skimming through it today, and I said, we got to keep going on this subject. It's too goddamn important. The rights analysis, not the right apostrophe S, but the analysis of rights done by the court here is horrifying. and to know that these are some of the highest jurists in the nation, applying law at the most critical levels. It should give us all pause when we look at exactly how they're doing it. And the only way to take pause in that is to actually look at how they're doing it. And I think, we went through the Second Amendment analysis that they did, and I have tons of problems with their analysis of Heller and McDonald and their application of those. But then taking that analysis and actually applying it to the cases just makes it worse. And I think we need to look at that because, man, what seems to be plain and straightforward just isn't for people who want to remove rights. And that is something to discuss and explore, like a good wine or whatever. I don't know what else you discuss and explore. Nature? Do people do that anymore? Is nature a thing that people discuss and explore? I'm not sure. But yeah, aside from that, Valhalla Awaits is in the chat. What's up, Valhalla? How you doing, brother? You guys should check him out on Twitter as he tries to figure it out. So that's fun. Next, well, the other main topic for the night, I got a message today. My friend, now friend, it's interesting how life works. Some subjects that you cover as a YouTube idiot become something more tangible, like a friend. In this case, my friend Lucas Gerhard had a victory in court, and he is now, his record is cleared of his alleged criminal activity. It is no longer criminal activity. He is someone without a criminal record now. If you remember or not, he was prosecuted and charged with terroristic threats for posting a picture of his AR-15 to a group of friends on Snapchat, having one of those group of friends show a person who he had specifically blocked on Snapchat or who had blocked him, and that person feeling threatened by a message that they were never supposed to receive, and then calling the police and saying that he was going to murder an entire school. All of that being a complete fiction about Lucas, who is making a joke that just happened to involve an AR-15 and his very fully legal transportation, usage, and storage of said item got turned into a nightmare that took years of his life and locked him in his home. Not in the COVID way where you could kind of go out, but in the real way with an ankle monitor and with limited, if any, access to any type of media, social media, internet, anything at all. From the time he's 20 to the time he's 21, which, can you imagine that being imposed upon you for something that is entirely protected First Amendment speech? But his record is now clear. It's a great update. There's not a lot to talk about. I just really want to celebrate that for him because, he had this deal that was worked out that had a stay of adjudication effectively, which means that a sentence is assigned by a judge for facts that are pleaded to, and that sentence then is stayed, not just the sentence itself. That's a stay of execution of the sentence, but a stay of adjudication means that the adjudication of the case itself is stayed pending a probationary period where nothing else of similar circumstances occurs. And if you complete that probationary period, then retroactively the case is dismissed. If you violate something during your probationary period, then they have sufficient basis to find you guilty of the crime and actually impose the judgment and then the sentence upon you. So his stay of adjudication, I believe effectively how that works out. I think Wisconsin or Michigan uses slightly different terminology, but that's the concept, is that that effectively he pled to a set of facts that a judge in theory could use to find a guilty verdict for him. And then it was stayed based on an agreement. It's really a fantastic way to resolve a case. It's not the ideal resolution from a purist standpoint of saying, hey, we should win this on constitutional grounds because what he did, effectively, Lucas didn't do nothing wrong. He used protected First Amendment speech in protected mediums. He didn't convey any threats to any person, and people lied about him to craft a narrative based on their disagreements with his politics or political beliefs, and then they used that to use the force of law and government to suppress his rights for years of his life. He is the victim of sanctioned criminal activity under the guise of a criminal act that he never did. But motivated judges who refuse to dismiss cases on purely obvious constitutional grounds, appellate judges taking ridiculous reads into facts about the case and determining that, no, there might be something there, and then leaving it in the hands of a jury isn't a way to win on that constitutional principle. The constitutional principle is winning as a matter of law, not winning as a matter of jury. And since he was not able to get that constitutional victory via dismissal that he should have had, and make no mistake, what happened to him is an absolute abuse of the system at all levels, all levels. But fighting it requires massive amounts of money, time, and ultimately the endurance of punishment that is undue, with a massive amount of risk attached to it that the punishments will attach forever. The alternative being working out an agreement where your record is preserved, your rights are preserved, and you are able to get away from the thumb of government that has oppressed you. That's a win every day. And now it's complete. So thankfully, he's now a little bit more free, and maybe we can get him back on the show to talk more about his life and his experience, a little bit more about the case. Last time we talked to him, there was some kind of restraints on what he couldn't say, but he is now outside of the ambit of the Michigan government. He is done. He is free. He is now the same as any other situated person. So that's great news for him. I'm super happy for it. And to those of you who were here throughout the reporting on that case, I have to share something with you. Legitimately, he would probably be in a completely different position if it wasn't for you guys. If it wasn't for y'all, if it wasn't for the support from people on this channel, of course, other people as well, but just the community support, the donations to the GoFundMe, things like that, for impossible legal fees over an obviously protected bit of speech with a motivated group of monsters. You guys, frankly, you may never know it. You may never feel it. Those of you who did as much as taking a look at his campaign, offering a prayer of support, maybe sharing it, tweeting it, donating a couple bucks, to donating any number of dollars, all of that is stuff that you saved someone's rights. You saved someone's life in the real respect of being able to live it as a free person. And so, personally, thank you for that. He seems like a really good kid. He's not a kid anymore, but he seems like a really good dude. And that's you guys who did that. So that's really cool. And I just wanted you to know that, because sometimes, you donate money to something, or you share something or whatever because someone asked you to, and then you never hear anything about it. But this is one of those where, like, your donation, your thoughts, your sharing, your comments mattered in a very real way. This is not a guy who had millions of dollars of fundraising for him. His case had national attention for a day, and then everybody else kind of stopped talking about it. So y'all really made that big difference in his life. So thank you. But yeah, we'll talk about that a little bit more in depth near the turn of the hour, before getting back into the Second Amendment thing. And then I've got the What the Fuck Wednesday submission thread up, so maybe we'll get into that. And Yeah, we're just gonna have a good time, I guess. I don't know. Maybe we won't have a good time. But look, even if you don't like it, I will, and that's the outcome that we're looking for. You liking it's a bonus. No. Anyway, we're gonna do that. Oh, people are out there. I did see some people in the chat talking about Alpha Core, the latest Rippaverse release, having a very strong opening on pre-orders. If that is something that you guys, are into, go grab your pre-orders of Alpha Core and have fun participating in the massive, ridiculous fight going on online about it. If you want, I'll watch from the sidelines with my popcorn. Now, with that, let's get into this in just a second. Rob Price's life is like your nose, long, bumpy with a twist at the end. Lamau. There you go. It's true. That is accurate. That's a thing that exists. Big Cheese says, "Hey Nick, when is the Cyber Frog review?" Soon. One of the reasons I don't review most things is because I just I don't spend a lot of time reading or engaging media. I just haven't in a while. It's not really a conscious choice. It's that lately, when I have a few moments, I typically end up getting some sleep. Yeah, I used to do a lot of video game playing, movie watching, reading. All of those things have gone so far by the wayside because of how my life is currently. I don't want to say ordered. We'll say disordered. But trying to get back into forcing myself to make that time for enrichment and leisure is something I want to do. And the Cyber Frog review is going to be a good opportunity to do so. I do still intend to do that, and hopefully just rip on it entirely and make Ethan Van Sciver cry. Because I feel like if he cries, that apple pie filling will come out of his eyeballs, and I can collect that and make another pie. You thought I didn't know how to read? Well, I don't. So that's true. With that, let's pop into this Minnesota issue first. This is the issue of Trump being kept off of the primary ballot. I'm going to take a look at the article first, and then we'll take a look at the ruling. Neither is super long. I debated doing the article at all, but this is, I think it's good. I think it's good here. So Minnesota Supreme Court won't remove Trump from GOP primary ballot in 14th Amendment challenge. So this is the first and most important aspect of this case. This is not a challenge to Trump being on Minnesota's general ballot, because we don't know if Trump will be on Minnesota's general ballot. Now, it seems like he probably will. Polling suggests that Trump will be the candidate for the Republican Party outside of some dramatic event that would probably involve death or something akin to death, something similarly unexpected, before we would see anything different happening. But they are trying to remove him from the primary ballot. And that was the attempt here. This went to the Minnesota Supreme Court, and they said, nope, he gets to stay on the primary ballot. But does that mean they do a full 14th Amendment analysis here and determine whether or not they even have the power to do this? No, of course not. That would be sensical, but that is not the issue before the court. So the Minnesota Supreme Court on Wednesday rejected an attempt to block Donald Trump from the state's GOP primary ballot next year based on the 14th Amendment's insurrectionist ban, but said the challengers can try again to block him from the general election ballot if the former president wins the Republican nomination. The 14th Amendment, ratified after the Civil War, says U.S. officials who take an oath to uphold the Constitution are banned from future office if they engage in insurrection. But the Constitution doesn't say how to enforce the ban. It has only been applied twice since 1919, which is why many experts view these challenges as a long shot. I don't know the details of it being applied twice since 1919, but I would wager it was not for the president. That's what I would wager. But there's no citation here to what it might be, so who knows? Maybe they'll cover it later. The ruling is a victory for Trump in terms of keeping his name on Minnesota's ballot for the 2024 GOP primary, where recent polling shows he has a commanding lead. However, the Minnesota justices didn't get as far as Trump's lawyers wanted, which was to shut down the case altogether and keep the former president on the ballot for both the primary and general election. Quote, there's no state statute that prohibits a major political party from placing on the presidential nomination primary ballot or sending delegates to the national convention supporting a candidate who is ineligible to hold office, the High Court wrote in a 4-page ruling, which didn't address Trump's eligibility. Rather, it said there is no error to correct at this stage. Therefore, the court dismissed the case, but said it wouldn't stop the challengers from bringing a petition raising their claims. As to the general election, by dismissing the case now, the justices did not reach the key legal question of whether the January 6, 2021 attack on the U.S. Capitol was an insurrection, whether Trump engaged in that insurrection, disqualifying him from office. And how could they? How can they do this? This is the ongoing sort of mantra around this question. Is like, well, the courts didn't get to a court in Minnesota. Think of this practically. A Minnesota state court is being asked to determine whether actions that did not occur in a state but occurred entirely on federal property or federal land in a federal jurisdiction of Washington, D.C., that if actions occurring entirely in Washington, D.C. amount to an insurrection in the first place, there's no actual, there's not like a finding of insurrection. I don't think Congress has even made a resolution finding an insurrection on January 6th, but I guess that would be a possibility. But they're being asked to determine as a state court, without hearing evidence from the jurisdiction, within the jurisdiction, or from anyone involved, that an insurrection occurred and that a non-party to the suit engaged in said insurrection. Donald Trump is not party to these suits. The Secretary of State is being sued by someone else who wants to keep Trump off. This court likely wouldn't even have the authority to bring Donald Trump into Minnesota to sit or to respond to a subpoena or to sit for a deposition or anything like that. He's not here. None of the acts predicate to the question are here. They're not even in a state jurisdiction at all. But yet they keep doing this. Like, well, this court, we wanted them to determine if there was an insurrection and that Trump participated in it or engaged in it. Well, how could they? That's not an issue for any Minnesota court to determine. You would need a DC court to make a determination that insurrection occurred, a federal court, at the very least, in my opinion, or some act of Congress. But alas, they're just hoping for the right judge. The challengers, a bipartisan group of Minnesota voters, could appeal Wednesday's decision to where? The U.S. Supreme Court? It's at the Minnesota Supreme Court. The rulings of the case is being dismissed as not to impair the orderly election process. The state's GOP primary is scheduled for March 5th. There were no noted dissents in the court's order, which was signed by Chief Justice Natalie Hudson. At oral arguments last week, several of the Minnesota justices appeared skeptical of removing Trump from the ballot. Hudson said it might be prudent to exercise judicial restraint, while another justice noted that the idea that voters should probably be the ones who decide whether Trump returns to the presidency. Oh, really? So I've talked pretty extensively on this subject and the problem with utilizing the 14th Amendment in an enforcement capacity like this. The president is a special animal. The president is a very special creature in U.S. law. In fact, I was responding to a stupid comment on YouTube today that was from a video a while ago, and the person said, "Do you believe that Trump is above the law?" And my initial response was, above the law is a stupid expression, because it is. Just because a bunch of unthinking morons bandy it about on Twitter and on major media does not mean that above the law has any tangible meaning at all. Let's put it this way. Trump, as a former president, is treated differently than you and I are under the law. And he is treated better than you and I are under the law, but he is still under the law. He's not above the law merely because he is granted specifically different treatment than we are. All presidents and former presidents are treated differently under the law. That doesn't make them above the law. It means that the law has vaulted ceilings and some people are in the right rooms, including Congress. There are different rules. They act like the law is a universal constant that is applied evenly. It's not written that way. Congress, as I harp on over and over, has the ability to legally insider trade. What Martha Stewart did sent her to prison and would send you and me to prison. It would not send a congressperson to prison. They have an exception. They have a carve out. If a congressperson on the way to session were to chop someone up with an axe so that they could get to the door, they can't be arrested until session is over. That's a different treatment. Is it them being above the law? Well, no. Presidential immunity, congressional immunity, judicial immunity, qualified immunity. All of these things are different. Your police officers are treated very differently under the law than you and I are. You can't really look to Chauvin, but you can look to plenty of instances where cops are not prosecuted for murders that are pretty damn obvious. And that if any other person in any other circumstance had done the same thing, it would be murder, not even a question. And the jury trial would happen very quickly. But hey, we're treated differently under the law based on any number of factors. And that's not even taking a cynical position of, well, systemic and endemic institutional racism means that whites are treated better under the law than blacks are. Some ridiculous social justice argument that plenty of people fully and full-throatedly adhere to and accept. And yet they will still say, well, do you think that somebody is above the law? It's like you just said white people are above the law compared to black people. So yes, I guess Trump is. He's kind of orange though. But they'll accept all these premises. They will hold them in their head consciously and then disregard it when they consider this statement, because the statement is so handy for them to just merely say above the law, ergo Trump bad and should be held responsible for what he did, even though what he did is likely protected presidential activity and he is immune from prosecution from it. It's so frustrating to deal with this shit. But the reason that the president is a special animal, the reason that the president has the power to pardon and has the power to pardon himself and his family, is that above the law? No. Joe Biden could pardon Hunter Biden right now for any federal crimes, even ones he's not been charged with. He could give Hunter Biden a clean slate tomorrow of any crimes he may have done up until the date and time that the order was issued at the federal level. He can't do it for state, but he could do it forever. Does that make Joe Biden above the law or Hunter Biden above the law? No, that's within the law. It is wildly disparate treatment. It is completely foreign to us peons to have the ability to do that. But the president gets that power under the Constitution for a very specific reason. Because a lot of people like him. Whoever wins the presidency, a whole shitload of people like him. Even if it's Joe Biden, a barely functional, senile, ridiculous person. Still a lot of people like him, like an unfathomable amount of people are like, yeah, Joe, he's good. He's good. They may not know him. They may not have a good basis for it, but they do believe that. That's why they voted for him. He's good enough to beat Trump, someone else that they know. Would that we were all that popular. But that level of popularity and that level of ascension through the political ranks to the office of president affords them a level of special, specific consideration, because for somebody else to remove the political will of a majority of Americans is a level of power that the founders weren't quite comfortable giving. And it's not just in this context. There are many contexts where the president is treated very specially. He is a king for 4 years. He is the king for 4 years, subject only to constitutional limitations that are given in our consideration, and the powers of the legislature, which are powers that were taken and derived from the executive authority of monarchies and instead distributed to an elected group of representatives. They received a defined set of powers that came from and belonged historically to kings. But the president of the United States reserved all other powers of the king to himself. That's the first line of Article 2, Section 1 of the Constitution. The executive power shall be vested in a president of the United States and the executive branch. That's it. The executive power in 1791 is the power of the monarch. And outside of subjected, enumerated limitations, they have those powers. And when they flex them, they win. They don't always do it. But when they flex them, they win. It's why FDR won against the courts. It's why Ronald Reagan won against the FAA. It's why presidents have hilarious authority that they don't always exercise. But when they do, man, is it funny. It's why Andrew Jackson was able to say, the Chief Justice has made his ruling, now let's see him enforce it. Because they operate on handshakes until they don't. That's why it's questionable if Trump can even be prosecuted for classified documents as the person who gets to determine if they're classified without question. It's a plenary authority of the president. So all of that to say, this is the most sensical line about this. Another justice nodded to the idea that the voters should probably be the ones to decide whether Trump returns to the presidency. And note, the only limitations on running for the president are that you are a natural-born citizen who has reached 35 years old and has spent some number of years as a resident of the United States. And I think it's like 10 or 6 or something. I don't remember specifically, but that is it. There's no felony disqualification for running for president. You can be president from prison. You can be president from anywhere if you can win the votes, because you are representative of the political will of at least half of the country. And that is remarkably, remarkably powerful statement, because the country gets to decide who they give that to. And why should a document, why should a group of representatives, why should a judge have the authority to take that away from the political will of the majority? And more importantly, why would they have the ability to take that away without it being very clearly and specifically drafted in our controlling legal document? When you look at the language of Article 3 of the 14th Amendment, the disqualification clause, it was written very specifically for a group of people who are very obviously disqualified from office. They were representatives, typically, who had sworn an oath to the Constitution, or governors or whoever had sworn an oath. And those people then participated in the most overt insurrection in the United States history, the Civil War, where arms were taken up with organized ranks and declarations and political affiliations and motivations, and a new president, a president of the Confederacy, a separate nation for a time, had occurred. Easily discernible, obviously obviously, notoriously applicable to the people it was targeting. And importantly, that clause does not say how to disqualify them because they were automatically understood to be disqualified. That clause merely states how you can forgive them and allow them to be qualified again under the Constitution, which is a powerful indictment of any attempt to use the clause of the 14th Amendment to disqualify a president. And let's not even get into the very basic fact that despite naming several specific positions, the president and the vice president are conspicuously absent from the list. That should not go unnoticed. But I've said all this before. The reason for all of this is that the political will of the governed is a powerful tool. It is the fourth branch of government. The fact that, or the fifth, in my opinion, the fifth branch after the administrative branch, which is the fourth, but the fifth branch of government is the idea that our political will is still manifest, and it is still manifest powerfully under the law in our own way. The only way to defeat the political will of the people is to subvert it through deception or fraud. So discounting that political will and flippantly throwing it away because some group of judges in a state can make that determination arbitrarily is nonsense. But hey, let's decide it on these bullshit issues anyway. In a statement, Trump campaign spokesman Stephen Chung said the decision is further validation of the Trump campaign's consistent argument that the 14th Amendment ballot challenges are nothing more than strategic, unconstitutional attempts to interfere with the election. I agree with this. Notice none of these people will be charged. Trump is charged for bringing fictitious lawsuits, right, to interfere with the election. All of these would merit the exact same criticism if anybody had any fucking integrity. Matthew, how you doing? Guys, my dude Matthew Franzis, I can never remember how to say your name. He's in the chat. Very good chap. He says, what's your take on Section 5 of the 14th Amendment, which states that Congress shall have the power to enforce by appropriate legislation the provisions of this article? First of all, Article 3 is one part of the 14th Amendment, but remember what Article 3 is. Article 3 is the process by which the removal of the insurrection label is applied by, I believe it's a vote of 2/3 of Congress. So there's that. Second, though, enforcing the provisions of the 14th Amendment by appropriate legislation is very easily and obviously done. Congress has done this from the start. They make law based on what the 14th Amendment says, which has stuff like equal protection. We see the Civil Rights Act is effectively an extension of the 14th Amendment, or an enumeration, codification, we'll say, of the 14th Amendment in law and in regulation, which says that here, no one can be deprived of their legal rights. Here's what that means. Here's how Congress is interpreting this and applying it directly through the Civil Rights Act of 1964 and subsequent modifications, so on and so forth. The idea that Congress gets to, by legislation, enforce the ideas of an amendment allows for flexibility without a constitutional amendment process, so long as the achievement of the goals of the amendment are, I guess, pursued. And we see a lot of that. And I know you know this. I would assume you agree because I'm, kind of cocky like that. But I know you know this, but we see a lot of that in other legislation where Congress creates a department and it gives that department authority within itself, within its own processes, to achieve the effect of the legislation which created the department, right? This is why with Chevron deference, we have the ATF ability to define things as firearms that were not defined as firearms. I don't really agree with their use of it, but the concept is, following the sort of ideas behind the National Firearms Act or the Gun Control Act, the ATF is able to create internal processes that have the effect of law, and they're able to pursue their purpose, their lawful purpose. We see this with the EPA as well, its ability to regulate new chemicals that aren't specifically named. We see it with the DEA and their ability to make determinations about controlled substances, for example. We see it with the Department of Education, their ability to implement policies that go ahead and follow the education bills, immigration, naturalization. All of these things have this sort of stuff baked in. The 14th Amendment just provides a model to do that as well at the constitutional level without requiring constitutional amendments. Whereas when Congress does it, it's without requiring a subsequent act of Congress. I hope that adequately explains it. And if not, and if you think I'm wrong, please make fun of me. Oh, I see. Great follow-up question. He says, so wouldn't the only way to remove Trump under the 14th Amendment be through an act of Congress, not our robed masters? That's the interesting thing. Let's do it real quick, though. Let's do it real quick. 14th. Because I think the language of the 14th Amendment, first of all, I actually think the 14th Amendment, Article 3 is dead. Dead language that is completely useless after the Civil War and Reconstruction. That's my personal opinion. I know not everybody holds that, but let's take a look at it. And I'll show you why. So again, here's the language. So here's the language you're talking about. Congress shall have the power to enforce by appropriate legislation the provisions of this article. But you have validity of the public debt authorized by law, including debts incurred for payment and pensions and bounties for services and suppressing insurrection or rebellion shall not be questioned, but neither the U.S. nor any state shall assume or pay. So that the U.S. Congress can enforce by legislation the authorization and payment of debts, for example, like which we see happen all the time. But going back to this section, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial official of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof, but Congress may by a vote of 2/3 of each house remove such disability. My opinion on this is that this was a singularly executable clause of this amendment that applied specifically to known obvious actors during the Civil War. That's my opinion on what they actually meant there. I do not think that this was an ongoing determinative effect. And the only way I could see it being applied subsequent to this would be to literally have another open insurrection against the United States akin to a civil war, not akin to a political act that we dislike. That's my opinion on it. But I would agree with you that if there were going to be a label of insurrectionists, in theory, Congress would be able to apply that label through this act. I don't know if it's ever been done, though. I don't even know if the individuals during the Civil War were named by an act of Congress. I think it was so self-evident who they were talking about and that the description was sufficient to specifically call out every single person that they wanted to call out. Yeah, Matthew says, the issue seems to be who gets to decide that a person has violated Section 3. Right, and it's a great question. Seems that Section 5 says only Congress. I agree that this should be a dead provision. And I would agree that if anyone can, it seems like only Congress can do it. The one thing that I don't see, like, you said never been done unless I overlooked something. That's my understanding too, is that even after the Civil War, Congress didn't do it, which to me is more is just as much in favor as the dead provision. It would also get off my screen. It would also easily and obviously explain the notorious absences of the presidency and the vice presidency. Lincoln, and whoever his vice president was, I don't even remember, did not engage in insurrection. They wouldn't need to be named. The people running for office, like Jefferson Davis wasn't running for the presidency. There was no need for those named provisions. But the real question would be is, What if Jefferson Davis had run for the presidency? Would he have been allowed on the ballot? Congress may have removed his disability anyway. And there were lots of reasons to remove the disability from pretty much everyone involved. I talked about this a couple shows ago, but uh, people don't really pay sufficient respect to the level of state allegiance that existed at the time of the Civil War, just by the nature of logistics in the 1800s, how hard it would be to remove or to move to a different area, how much family lineage would be linked into your heritage in that place, how much religion was tied into it, and your religious upbringing and peers were very localized amongst the early states. All of this stuff just generated deep ties and roots to where you were. Your state was your national identity more than the United States was. That would come later. That would come after Reconstruction, actually. And so, these men who are in these states in the South, it's not like they could just, oh my God, we're splitting from the nation. Let me just hop on a Spirit airline, and we'll be delayed 12 hours, but we'll be in New York and we'll be in New York by the end of the day, and then we can safely declare that we're not part of the insurrection. That wasn't practical for most of these people, especially not the average citizenry. So what you had was state identity, and there would surely be adherence to the political majority, which would be predominantly in support of slavery in the South. But it doesn't mean that on some principled, deeply held, reasoned level that people overtly supported slavery. I mean, most average citizens didn't own slaves. Is the aristocracy who did, especially the ones who would own large amounts of them. And so what you're dealing with is this idea that the majority supported the majority's understanding of how the world worked. And so to hold people to those realities in a time where travel and communication were not so obviously accessible as they are now is a little disingenuous. But hey, our entire culture of commentary is about being disingenuous about reality, because being honest and confronting problems as they come rather than as we would like them requires us to take positions that are difficult. It requires us to examine if we actually would have stood against slavery in any capacity. Stupid little fucking bugs. But so anyway, that's that. That's that. Great questions, Matt. Dude, it was really cool to see you, by the way, the other day. That was awesome. And we got to get together and do lunch again. Thanks for dropping some good questions there in the chat. Speaking of that, EFO says, play America for freedom and democracy. Are we putting the people in the wrong? The flag means more than legal interpretations of our constitutional republic. Thanks. And then prayer hands. Okay. The Squid says, so the 14th can only apply to service members and politicians that are convicted of treasons in absence of a civil war. Maybe. we actually don't even know. We actually, there just isn't instruction on it. And again, I think this is why you find guys like me and Matthew arguing that it's a dead clause, because it is so specifically descriptive of a specific group of people that were notoriously known. It's not like it was hidden. It's not like some backroom deal was uncovered. I mean, they engaged the insurrection of the Civil War, usually by participation as some sort of officer or elected or appointed representative of the Confederacy. It's not hard to imagine them engaging in that insurrection. But it also only applied to people who had taken an oath of office. If a regular citizen became a soldier and then was elevated to the rank of general, having never been holding office in the United States or taking that oath, even for their state when they were in the Union, they would not be held as engaging in insurrection for the purposes of of Amendment 14, Section 3. Specifically excluded. They have to have previously taken the oath. So the average citizen, they're recognizing here that what happened with the officers of the United States, with the representatives, that they had taken an oath to a higher order. That higher order was higher than their mere living in a place. And it's really recognizing the difficulty or the logistical problem of proximity that says, hey, some guy in the middle of Texas is not fucking going to New Jersey, right? He's not going to make it up there before he's swept up into the Confederate Army. There's no way. And if he tries, he might get killed. How is he supposed to do that? So we're like, okay, well, there's a limited group of people here who we really need to know about. And you also didn't want a bunch of people come like, hey, you know, this guy, you know, that sort of secret reporting to fuck people over that is so popular these days. They didn't want that either. But yeah, I digress. It's a lot of discussion on the subject. I find it fascinating. I find it more fascinating that so many lawyers and scholars out there just disregard the obvious questions with all of this in favor of their political narratives. But let's get back to this thing. We're almost done with this article. These lawsuits should be summarily thrown out whenever they next arise, Chung said. Correct. Similar anti-Trump challenges are still ongoing in Colorado and Michigan. Closing arguments are scheduled for November 15th in the Colorado lawsuit, which last week saw witness testimony from U.S. Capitol police officers and other key figures at a week-long trial. Why? We have no idea. The cases have been handled by left-leaning advocacy groups, but a bipartisan array of legal scholars and former jurists have endorsed their attempts to disqualify Trump from office. They always do that because there's like one vaguely Republican lawyer. If you ever hear a lawyer call themselves Republican, like, you have every right to say, fuck you, liar. And you'll be right most of the time. Like, they're vaguely Republican, but do they hold on to the values that embody the current Republican Party? And that's not a moral endorsement of the current Republican Party. It's amoral. It's morally neutral, but they don't hold on to them, typically because law school will force you, and then entry into the legal profession will force you to engage people of such vastly different ethical and moral understanding than you have, that you have to have a lot of flex. And that tends to I don't want to say it in this way, but it tends to preclude a lot of hardlining on issues that Republicans tend to be very hardline on. I'm not saying that that's good or bad or anything. It just seems to be the natural outcome of someone going to law school. Oh, and the fact that it's overwhelmingly dominated by highly and specifically liberal professors and academics. So the challengers, a bipartisan group of Minnesota voters, could pursue an appeal of Wednesday's decision. Regardless of the initial rulings in the cases, most experts anticipate appeals that go all the way to the U.S. Supreme Court, which could settle issue for the entire nation. That's the only way we'd get any different interpretation than what we have now, which is none. We are disappointed by the court's decision, said Ron Fine, legal director of Free Speech for People, who represents the anti-Trump challengers. I wonder who Free Speech for People is. It's always curious to see what these, like, Free Speech for People. Free Speech for People is a leading force in the country for defending our Constitution and fulfilling the promise of political equality. Oh, that's interesting. I wonder what their if they have a mission statement or something. A national nonprofit, nonpartisan organization is a catalyzing leader in the country, challenging big money in politics, confronting corruption in government, fighting for free and fair elections, and advancing a new jurisprudence grounded in the promises of political equality and democratic self-government. Through our cutting-edge legal advocacy, public education, and organizing work, we're at the forefront of a movement across the country to defend our Constitution and reclaim our democracy. Since our founding in January 2010, on the day of the Supreme Court decision in Citizens United versus FEC, we've launched innovative and groundbreaking legal action to ensure people can participate equally and meaningfully in our democracy, advocated for model legislation to defend our core democratic principles in our Constitution, advanced new laws to end the big money dominance in our elections, and promote political equality for all. worked with lawmakers at the federal, state, and local level to provide key legal expertise and analysis on matters related to our democracy, challenge corruption at the highest levels of our government, engage in public education. Gee, I wonder how bipartisan they are. Let me just cast my doubts on it. But you know what? I'll take their word for it. Let me just gently say this in the best way. In the best way I know how. Anyone who opposes Citizens United's ruling, bear with me, you may be included in this, has either been fully propagandized or is an enemy of the nation and freedom. There you go. That's a tough one for people to swallow because you're told so much how much we don't want money in politics. And I will humbly implore you that money will always exist in politics and that Citizens United is the number one equalizer between protecting incumbent strongholds and challenging them reasonably in a way that campaign finance laws prevent normal citizens from having a shot at having their voices heard in an age of incumbents with unlimited fundraising opportunities and the full faith and credit of the United States government funding their non-campaign activities that happened during all of those off-election years and increase their Q scores, increase the propaganda around them, increase their name recognition and notoriety amongst the masses, something that would take literally hundreds of millions of dollars of free money to overcome. And then we limit the ability to collect that free money. And all the while, they have the same power to collect as the other person. They just get to do it the whole time while utilizing every aspect of media with their own government name tag to promote themselves for free. I will never back down from Citizens United being one of the most courageous and correct decisions of the United States Supreme Court in my entire life. That's what I got on that. And if you ever want to talk about Citizens United, come buy me a whiskey and I'll waste your entire year talking about it. So that being said, let's move on. Oh shit, we got this one from Nikki 941 over on Rumble, says checking in after 30 days of using the Brick House lean. Glad to say it helped me break through the 228-pound plateau, and I'm down to 225 at 6'2". The promo code works once. Use Salty's code for the second. So there you guys go. There's an actual testimony on Brick House lean from Field of Greens. Helped someone get past their weight loss plateau. Very cool to hear. Thank you, Nikki, for sharing. That's awesome. So here we go. Back to this. However, the Minnesota Supreme Court explicitly recognized the question of Donald Trump's disqualification for engaging in insurrection against the U.S. Constitution may be resolved at a later stage. Yes, they explicitly recognize that it might be resolved later without reaching the question. That's a very lawyerly way to put that. The decision isn't binding on any court outside Minnesota, and we continue our current and planned legal actions in other states to enforce Section 3 of the 14th Amendment against Donald Trump. The group's statement noted that the court didn't rule in favor of any of Trump's arguments against litigation, but rather dismissed the case on technicalities. Now, wait a minute. That's funny. I wonder if these people would have said the same thing about all of those election cases, which were dismissed on technicalities like latches or lack of standing. Because that's literally what this was. This was dismissed on a matter of ripeness, which we'll get to as we go. So none of these issues are ripe. We can't rule on them. Well, that's just technical. They lost at the frivolous lawsuits against Donald Trump right here by the standards applied by any honest and consistent application of the terms being used. It's amazing. It is astounding that they just do this and assume no one will ever make that connection, that the exact same statements were made about Trump's cases. Well, they didn't rule on any of the arguments. They literally ruled on procedural questions of standing, of latches, of the justiciability of it, of ripeness, of mootness, all of that. Derek Muller, an election law expert at Notre Dame Law School, who submitted a brief in the Minnesota case that was neutral on Trump's eligibility but provided analysis of key legal questions, said Wednesday's ruling kicks the can down the road. Political parties in Minnesota list nominees in the presidential primary, and the court here deferred to that process, Muller said. But the general election is a different matter. It's not run by the party, so the court is essentially inviting a new challenge later ahead of the general election. Correct. This is actually a fairly good summary of the order itself. So I don't know that we should bother reading the whole thing. That last bit kind of buries the lead, but it really gets to the core issues effectively here. We'll do this part really quickly because this is how it all matters. We conclude that petitioners, they do have standing, so they have the ability to bring this suit, and their claims are ripe as to the issue of whether former President Trump should be excluded from the Republican presidential nomination primary. Now, the reason they say this is ripe is because he's about to be included on that primary ballot, I think in January. So right now, he's going to be included on the ballot. There's nothing excluding him from the ballot. So the question is, can the court issue a ruling on the propriety of including him on the ballot? Can they say, and this is the legal way to word it, can they say that the Secretary of State, by including former President Donald Trump on the primary for the Republican candidate ballot, has erred in his or her decision to include Trump? Is that an error that the court can then remedy? And they've determined that's the only ripe issue. They have standing to question the Secretary of State, and they can ask the court to determine that the Secretary of State's inclusion of Trump is an error that can be remedied. They rule that no, it's not an error. And the reason they find that it's not an error is because, effectively, there's no law saying that he can't. In fact, there's no law saying that even if Trump is excluded, that they can't include him on the primary ballot, because the primary ballot is a completely separate animal than the general election. And they concede that if he's excludable at the general election level, they can still put him on the primary ballot, and there's no harm being done to anybody. It's not wrong because, again, there's no law saying he can't be on there by being found to be ineligible for a subsequent edition, saying the voters get to choose this, and if they want to choose the wrong person, they can. That's the reasoning given by the court. The other issues are not ripe. So with respect to the only ripe issues before us at that time, we include that under Section 204B44, there is no error to correct as to the presidential primary election, blah, 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 blah. The other issues, though, are not ripe. They cannot make a determination on his eligibility for the general election ballot at this point in time, because it's possible he won't be on there. Now, if he wins the primary, which he seems likely to do so, and then is placed on the ballot for the general election, that is when you would have to file. At that point, the issue will be ripe, and you can then try to litigate him off of the ballot. That's what will happen here, unless we get an intervening ruling from the Supreme Court on the issue generally, in which I really think the Supreme Court should take up this case, expedite it, and very quickly rule that this is nonsense. Without at least a conviction in a criminal court of Trump of insurrection, I don't see how they could even come close to finding him disqualified in any capacity. There's just no way. There's no factual determination that Trump did what is required to be disqualified. Did he? I don't think so. I don't think there's any way you can determine that Trump actually engaged in an insurrection. I don't think an insurrection occurred under any real definition of insurrection. That's my opinion. But hypothetically, you say an insurrection occurred. Did Trump engage in it? I still say no. The interesting question is, engaging is not inciting. Incitement is not engagement. Automatically, incitement can amount to engagement, I think, but I don't think incitement automatically is engagement. First of all, Trump hasn't been found guilty of incitement either. I want to be very clear on that. Some people just forego all of these legal conclusions. Well, he incited the insurrection. It's like, well, it's not an insurrection. He didn't incite it. There's no finding to that effect at all. Well, but he engaged in it. Well, there's no engagement in an insurrection that didn't occur. And even if one did occur, how would he have engaged it? Like, what did he do? He wasn't in the crowd. Well, he didn't tell them to leave. Well, one, he did, but even if you suggest that he didn't, he doesn't have a duty to stop an insurrection. He doesn't have a duty to do anything. So it's just wild. Play the fight clip again. Yeah. Well, and of course that was the big attempt by Jamie Raskin during the impeachment, was to try and say that Trump's use of words like fight and victory and stuff like that amounted to violent rhetoric that was invoking and encouraging people to take up arms against the country, which is nonsense. And of course, the fighting rhetoric has been used by politicians forever. The Squid says, given that only the worst actors weren't pardoned post-Civil War, it really sounds like someone would have to be convicted under the law before the 14th could even be applied. Yeah, and Matthew brings up an excellent point. I think they'd have to be convicted, and probably an act of Congress would have to be made, at least a resolution declaring something. There had to be a resolution of insurrection, maybe. Here we go. Proclamation 153 adopted a resolution in the following words: resolved that the present deplorable civil war has been forced upon the country by the disunionists of the southern states, now in revolt against the constitutional government and in arms around the Capitol, that in this national emergency, Congress, banishing all feeling of mere passion or resentment, will recollect only its duty to the whole country, that this war is not prosecuted upon our part in any spirit of oppression, nor for any purpose of conquest or subjugation, nor purpose of overthrowing or interfering with the rights of established institutions of those states, but to defend and maintain the supremacy of Constitution and all laws made in pursuance thereof, and to preserve the Union with all the dignity, equality, and rights of the several states unimpaired. As soon as these objects are accomplished, the war ought to cease. And so that there are resolutions, at least. Oh, whereas by my proclamation of the 13th day of June last, the insurrection in the state of Tennessee was declared to have been suppressed, authority of the United States therein to be undisputed, and such United States officers as had been duly commissioned to be in the undisturbed exercise of their official functions. I think this is a proclamation by the president, Andrew Johnson. So here you got, declaring the insurrection in certain southern states to be at an end. So there's at least a presidential proclamation of an insurrection, recognizing proclamations from Congress that were resolved by the House and the Senate. So I think you have there at least some acts of Congress. Now, that was in 1866, whereas the 14th Amendment would be passed in 1868. So, or adopted in 1868. So not necessarily a subsequent act of Congress, but you at least have acts of Congress and the presidency labeling an insurrection to have occurred. That's pretty official. There's not many other ways you can really imagine that occurring. So we've so many differences between what happened and the attempt to liken January 6th to anything comparable to Civil War or to an attack like 9/11 or any other sort of treasonous act that we've seen is so radically dissonant with reality that I have trouble fathoming it. Like, still, when I think about it, I'm like, I'm not the biggest fan of January 6th, but I get it. But there's no way we can determine that that was a sufficient and similar threat to the fabric of the nation as the Civil War, or even traitors, treasonous actors during World War II or World War I. I mean, remembering the steps that we took during World War II, what has happened to the January 6th defendants is appalling. Make no mistake. But what happened to the Japanese Americans during World War II? is of a kind of even greater disgust. And let me tell you why. Because at least the January 6th defendants were there. What happened to the Japanese citizens and Japanese American citizens, American citizens of Japanese heritage in the Western, I guess, quarter to third of the country during World War II was a condemnation of them by blood, not by act, not by presence, not by some citable event that was attended. Literally, you are this thing. And it wasn't just the Japanese. They just got it the worst. Germans and Italians were treated the same in both World War I and World War II. They just didn't have the camps and internment that happened after that. They had struggle sessions. They had interrogations. They had all sorts of suspicion just based on their heritage, by the DNA inside of them. And that is a category that is offensive to our the notions of freedom and liberty in our nation, and also to the direct command in the Constitution that no attainder of blood shall apply in matters of treason. Yet, we did that thing. So where I'm going with this, though, is simple. What we did in World War I and World War II is shocking. What's happened to the January 6th defendants is also shocking, but is still of a lesser character than what happened there. Now, interestingly, there isn't an act of insurrection that can be specifically pointed to logically link a nexus between the people persecuted in 1944, as there is at least in January 6th, is worse treatment and still not an insurrection. Treason was treated individually amongst individual actors from those groups, if any were even found. January 6th, they haven't labeled that an insurrection either outside of the media. They can't. How would you? Who would do it? A court? Sure, there's someone who's been found guilty of it or pled guilty. I think one of the Proud Boys, maybe not one of the Proud Boys, maybe the other ones, Oath Keepers, I think, pled guilty to incitement of insurrection, which a guilty plea does not make much of anything of use, in my opinion. But that's still just a determination of one person to an act commensurate to an insurrection that doesn't actually require an insurrection to have been found. I think the only people who could label an insurrection would be Congress or a president. And probably only Congress, since they have the power to declare war. But maybe a presidential act suppressing insurrection through the militia would be sufficient. But we didn't even have that. Anyway, now I'm just going through a whole bunch of stuff in my head going, how the fuck are they even making these determinations? No one is. We're all just pretending that they are. Sherry Lawlessness with a giant super chat. Thank you so much. This is 1.5 years ago. You toasted my 98-year-old grandpa after a bad fall. We didn't think he'd make it. He fought and survived World War II and injured during the Battle of the Bulge. I just left his 100th year birthday party. He's so great. I'd appreciate another toast from you. Oh my gosh. That's not John Porton, is it? I see you in the chat. John, is that the you I know? Because if that's the you I know, people out here should know that this is entirely your fault. And I know you got to hate that. And that makes me happy. Sherry Lawlessness. A cheers to your grandpa. A century of witness of this country, a century of witness, a century of making friends, of losing friends, of making connections, of building networks that extend far beyond anyone's imagination, of watching technology triumph over the insufficiency of our ability to connect, and watching people triumph over their prejudices, their violence, their failures, and work towards something bigger than any of us could have ever imagined. A man who has watched it all from the sidelines would be commendable for the horrors and triumphs he has seen. But a man who fought for those very principles is something to be recognized a step above. Cheers to him. May he have as many more years on this earth as God will grant him. All right. Okay. We've got a couple more super chats, and then we will move over to Rumble here. And then we'll continue on with the show. Valhalla Wait says, I have a goat that would be a better president than Joe Biden. Mike Wells says, can you give a shout out to my friend Aaron Yeager, who was killed this weekend after committing mass genocide? What? Oh, okay. Got it. All right. I didn't get the reference. Wait, he's dead? To Aaron Yeager, a true visionary. May his goals of a cleanse someday be realized, though he was thwarted. I don't know who by, but I have a feeling it was Levi. Cheers to him. Oh my God. See, Goody says, F for my cat, Samson. Sam was the bestest boy. He had bunny soft fur and he'd plop right under your lap and love you. Pass this weekend. Nearly 18. F. F's in chat for the cat. Sorry, Goody. That sucks. EFO says, save the Bay Area from Democrats. Good luck. Good luck. Eric Sean, what's with the self-imposed struggle session every time you're about to bring up a Trump-related topic? I'm pretty sure most of your audience isn't anti-him. It's not that. It's just, it's really easy to get wrapped up in this idea that everything you say about Trump is based on this cult of personality, idol worship. My assessments of Trump are based on my opinions and assessments of his actions and the law as it is written and understood. That's it. I just want to make clear that it's not Trump because Trump. It's Trump because I just don't think the law has anything to do with many of the topics. And I think the dishonest dismissal of it is really fucking irritating. Kate C, aka Snake Plush Kitten, says law school teaches you not to think in right versus wrong, but in legal versus illegal, which are changeable in seconds. True. Also arguable. Don't forget to think in the arguable. Shy says George Takei blows my mind with his constant support of Democrats, considering he and his family were sent to a camp by FDR, Democratic president, using an executive order. Peak Stockholm syndrome. Oh my. Well, I really learned a lot in those camps, if you know what I mean. Not all of our pants were on the entire time. Cynics Processing says, I'm British, so my bad if wrong. Is Trump being charged for something regarding January 6th, or is it hyperbolic rhetoric to try and taint any jury's opinion? He is charged vaguely with conspiracy to interfere with an election, and some of the events and statements around January 6th are included in that general charge. That's about it. But even that is questionable as possible, because that is only findable after a determination of guilt, because it requires so many negative inferences about the actions and the legality. Any presumption of innocence at all would support the idea that he's probably immune from those accusations entirely. But hey, we have to see that. We have to see someone actually make that determination until it goes to the Supreme Court. to find out if presidential immunity applies to criminal acts, then we just got to wait. All right. Let's go ahead and pop over to Rumble, I suppose. Oh shit. Sherry Lawlessness says the only downside is he can't hear worth a damn and wakes up every morning thinking, what the fuck, but still has all his wits about him. Thanks for what you do. Sherry, again, cheers to him. Still sounds like a great and impressive man. And though he can't hear, I bet he has phenomenal stories of a world we can't even envision. So love him and spend as much time with him as you can in these last years, because everything he has to share is of value. All right, guys, pop on over to Rumble. You can find the link in the description on YouTube or in the pinned chat. We've got to briefly talk about Lucas Gerhard and then go back into our Second Amendment analysis provided by the Seventh Circuit Court of Appeals, doing what is, in my opinion, one of the most offensive Second Amendment analysis I could imagine happening after Bruin. But hey, it is what it is. All right, guys, we'll see you over there in just a minute. Otherwise, we'll see you tomorrow. Have a good night. Peace. Peace.